Okay, so if you're prepping for an evidence exam, you know exactly where the points are won and lost, the hypotheticals. So in this explainer, we are going to walk through a classic fact pattern, step by step, really just to sharpen those analytical skills you're going to need on exam day.
All right, let's just dive right in. We're putting you in the lawyer's seat. Your client, Paul, is suing David for injuries from a car crash. And because the case is in federal court, that means we're playing by the federal rules of evidence.
And let's switch hats. Now you're the judge. The whole trial really hinges on two key pieces of evidence, and it's your job to rule on whether they're admissible. If you get these right, you'll have a really solid handle on some of the trickiest concepts in evidence. But first, we've got to set the scene.
Okay, first up, the facts. You know, in evidence, every single detail matters, so let's break down exactly what happened here.
So here's the sequence of events, and I want you to pay really close attention to the timing. We have a statement made just before the crash, and then another one that gets documented just after. As you're about to see, these timestamps are absolutely critical for our whole analysis. All right, let's tackle that first piece of evidence. This is the statement from Paul's passenger, Vera. Now, she was tragically killed in the crash, but just 30 seconds before impact, she told Paul she saw a black SUV weaving recklessly.
Before we dive into the deep end with hearsay, we always have to start with that threshold question. Is it even relevant? So, under FRE 401, evidence is relevant if it has any tendency to make a fact more or less probable. Here, a statement about reckless driving, that goes directly to the central issue of who's at fault. So, yeah, it's clearly relevant.
But here's the real hurdle. Vera isn't in court to testify, right? We're hearing her words through Paul. So is this inadmissible hearsay? Let's break it down.
So let's just walk through the definition real quick. Was the statement made out of court? Yes, in the car. Is it being offered to prove that the SUV was actually weaving recklessly? Yes, again. That's the textbook definition of hearsay. So that means it's out, unless, of course, we can find an exception that lets it in.
Okay, so here we have the two most likely exceptions, and this is a classic exam trap. You see reckless driving, and your brain just might jump straight to excited utterance. But what's the key fact here? The hypo says Vera was speaking calmly. That one little word, it completely kills the excited utterance exception, because that rule requires stress or excitement. But it lines up perfectly with present sense impression.
Let's just map the rule right onto our facts. Is it a statement describing an event? Yep. Weaving recklessly. Was it made while she was perceiving it? Yes, it was contemporaneous. That is just a clean fit. So the court was right to admit this statement. It's a textbook present sense impression.
All right, let's move on to the second piece of evidence and see how this gets a little more complex. This is a photocopy of notes that were taken by Molly, a witness at the scene. And in these notes, our client Paul supposedly admits he was at fault. Yeah, this is a big one.
Okay, so what we're looking at is a classic hearsay within hearsay problem, which is governed by FRE 805. You have to think of it like one of those Russian nesting dolls. First, you've got Molly's written statement, her notes. That's your outer layer of hearsay. Then, inside that statement, you have Paul's spoken words. That's the inner layer. For this thing to be admitted, we need a valid hearsay exception for each layer.
So let's start with that outer layer, Molly's notes themselves. On the stand, Molly testified that she has no memory of the conversation. That immediately points us directly to the recorded recollection exception under FRE 8035. Let's see if the facts lay the right foundation.
Molly's testimony on the stand is absolutely key to laying the foundation here. So first, she can't recall. Check, that's a prerequisite. Second, she made the record when her memory was fresh. The facts say immediately after. Check. And third, she testified that it's accurate because she wrote it carefully. Check. The outer hearsay layer is solved.
Now for the inner layer, Paul's alleged statement that he was at fault. This one's actually much simpler. Under the rules, a statement made by a party and offered against that same party is defined as not hearsay. It's a classic admission of a party opponent. Paul's a party, and his own words are being used against him. So layer 2 is also solved.
So we're done, right? We've got a valid exception for the outer layer and a solid one for the inner layer. That means the court was totally correct to admit the photocopy of the notes, right? Well, be careful. This is exactly the kind of nuance where you win or lose points on an exam.
So the key, the real kicker, is buried right there in the text of the recorded recollection rule itself. It creates this critical procedural limit. See, the content of the notes can come in, but the document itself can only be read to the jury. It can't be admitted as an exhibit unless it's offered by the adverse party.
And that little procedural distinction is the key to this whole question. Think about it. David's lawyer is the one who called Molly to the stand. He could have just had her read the notes out loud to the jury. But instead, he offered the photocopy as an exhibit. And since David is the proponent of the evidence, not the adverse party, that was a clear error by the court.
So here's our final breakdown. The ruling on Vera's statement? Totally correct. But the ruling on Molly's notes? That involved a subtle but really critical error. Admitting the photocopy itself was just improper procedure under FRE 800-35.
Okay, so let's distill this whole analysis down into a practical blueprint that you can use to attack any evidence question on your next exam.
Let's really lock these takeaways in. For any kind of real-time statement, always check the declarant's demeanor. That's your cue to choosing the right exception. If you see a document with another statement inside it, just think Russian doll and analyze each layer. And for recorded recollection, please never forget that procedural punchline. It can be read to the jury, but it cannot be admitted as an exhibit by the side that's offering it.
So you see how a single word in the facts, like calmly, or just one little clause in a rule can completely change the outcome? Mastering evidence isn't just about memorizing the rules, it's about seeing these details. So the question this leaves us with is, what other critical details are you now trained to look for?